starting with the state, any concerns or objections to the verdict form?
Yes, Judge. As it relates to counts 1 and 2, the voluntary manslaughter is listed first in front of the murder. So it's listed as voluntary manslaughter or murder. It's the state's position that the murder should be first, as a voluntary is the lesser included. So that the not guilty of murder and guilty of murder should be in that first, and then or not guilty of voluntary manslaughter, guilty of voluntary manslaughter for each of that of murder and felony murder.
All right. And over on the defense side.
Man, I think the verdict form is fine as is, but whatever the court's pleasure is.
All right. Seeing as it's really just a matter of preference, and I don't think there's any legal objection to the verdict form, I don't see really the order as making a material difference. And at this point, we've already printed it, so I think we'll just go with that. Turning to the jury instructions.
How the law gets paid.
That's right. Judicial economy. All right. So turning to the jury instructions, any other issues with using this as the copy that I read to the jury?
No, Judge. No.
Okay. Any reason we can't proceed with closings?
No, yeah.
And Mr. Banks, will you be taking the lead on defense closing?
I told Mr. Walker my voice was out.
Don't look at me. It's y'all's. I'm just asking a question.
Yeah. So I think so, Judge. Yes.
All right. And for the state, do you want me to keep time and give you any kind of a warning?
Yes, I'd appreciate it.
When would you want a warning?
At the 30-minute mark, maybe.
In your first opening?
Yes.
All right. And then it should be noted, we said we were not going to use all our time. But
Oh no, we won't. I'm just.
Mr. Banks, do you want any kind of a warning?
I don't plan to.
No, we get 2 hours.
You do. And what I'm saying is at the hour and 55-minute mark, do you want a warning of something?
No, by that time I'll collect an offering and we'll see what.
All right. I will give the state a courtesy warning at 30 minutes. Oh, no, you're good. Yeah, take care. I was like, wait a minute, this is part of our jury. Okay, with that, let's bring in the jury. And for the record, I've marked a copy of the charges that I will give as Court's Exhibit 3.
All rise for the jurors.
Thank you, Deputy. Thank you, everybody. All right, good morning, everybody. We are going to dive right into closing arguments. You'll recall from the preliminary instructions I gave you before the trial began that argument of counsel is not considered evidence, and it's the jury's role and job to recall the evidence and come to their own conclusions as it relates to the matters you've been presented. So the state has the right to begin closing arguments, and so Mr. Lee.
Yes, John, we would be exercising that, right?
All right, the floor is yours, sir.
Thank you. Good morning, everybody. Again, my name is Jeffrey Lee. On behalf of the state of Georgia and Joshua Torrance, I want to thank you for being here, listening to all the evidence, paying attention. I saw many of you writing things down. I can tell you was focused on what was going on. I really do appreciate that. Okay. So Because the state has the burden of proof, I get to go first and last. So I'm gonna use this first opportunity to discuss the law that we believe is important to this case. It won't be all of it, but just pointing out a few things, okay? And you'll be given a full charge by the judge when it's that time for him to give it to you. So I want to start by talking about your duty as jurors. It's your duty to be, which you are, a fair and impartial juror, honestly seeking the truth. You are on a truth-seeking mission. A criminal trial is not about a search for doubt. You're always looking for the truth. It is your duty to deliberate, discuss the evidence with each other, and to consider the evidence, the exhibits that were presented, testimonies, photographs. And you're to only concern yourself with the guilt or innocence of the accused. You're not to concern yourself with punishment. That's for Judge McAfee to do. You're just to decide the facts, apply the law to the facts and decide what happened. And you're not to be influenced by sympathy for or against either party. You're not to be, there's nothing in the indictment that's gonna ask you to decide whether or not Mr. Collier regret what he did or anything like that. Your decision has to be based on the facts. What happened on May 30th, 2018? Again, it's a truth-seeking mission. Now, Mr. Collier enters this case with a presumption of innocence in his favor. And that presumption remains with him unless and until the state overcome that with evidence sufficient to convince you beyond a reasonable doubt that Mr. Collier is guilty of what he's been charged with. And the burden of proof rests upon the state. We accept that burden willingly and proudly. We have to prove each element of each offense beyond a reasonable doubt, and the burden never ever shifts to the defendant. He doesn't have to prove his innocence. Now, reasonable doubt, the state is not required to prove guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. It's a doubt based upon common sense and reason. It's not a vague or arbitrary doubt. If you have a reasonable doubt, you don't have to go looking for it. It's going to jump right at you, and you just can't get past it. An example that one of my colleagues gave that I found helpful in explaining reasonable doubt to you is, imagine something you may do every week. Go to the grocery store, pick out your favorite cereal. My son likes Cinnamon Toast Crunch. When I go and I get a box of Cinnamon Toast Crunch, like I've done many weeks before, even though I don't look in the box to see what's inside, I'm sure there's going to be Cinnamon Toast Crunch in there. Now, is it possible that maybe the cereal manufacturer made a mistake with that one particular box and there's Cheerios in it? Yes, it's possible, but is it reasonable based on my common sense and experience to believe that there's going to be Cheerios in that box instead of Cinnamon Toast Crunch? It's not. Evidence can be either direct, circumstantial, or both, and the law assigns no greater rate to whether the evidence is direct evidence or circumstantial evidence. Direct evidence is evidence that can be observed by the senses. I can see it, touch it, feel it, hear it. So when Mr. Clemens said, I saw somebody walking through the complex with a gun. But Mr. Durant said, I heard one gunshot when I was putting the trash in the compact. That's direct evidence. Circumstantial evidence is evidence that's not seen or heard, is proof of facts or circumstances by direct evidence from which you may infer, other related or connected facts that are reasonable and justified in light of your experience. The common example we give in explaining circumstantial evidence is, say it's January in Georgia, back when it used to snow. It hasn't done that in a while. I've been waiting for about 4 years since I've been back. But anyway, so imagine it's January, you go to sleep, there's no snow on the ground, the yard look the way it looked days before that. But when you wake up, you see snow on the ground, and you see footprints on the snow. Now, you were asleep, so you didn't actually see the snow fall down. But you can infer from your common experience and your common sense, there wasn't snow on the ground the day before. And now that there's snow on the ground now, that it snowed last night and somebody walked across your yard. Okay, even though you didn't see it happen, you can use your common sense and experience and what you know about the situation to draw that conclusion. The testimony of a single witness, if you believe them, is sufficient to establish a fact. Okay. Corroboration of a witness is not required, provided you find the witness's evidence or to be sufficient. And it's your job to determine the credibility of the jurors. And in deciding that, you can consider all the evidence, including the witness's manner of testifying, their means and opportunity for knowing about the facts about which they testify, the interest and lack of interest in the case, the nature about the facts about which they testify, the probability or improbability of their testimony, the interest or lack of interest in the case, and their personal credibility as you observe it. Now, the indictment charges Mr. Collier with count 1 murder, count 2 felony murder, count 3 aggravated assault, count 4 possession of a firearm by a convicted felon. And I'm going to take these out of order because I think when you're back there, well, actually, I got another slide that I forgot about, so let's talk about that. So judge is going to give you instruction regarding intent. And intent is an essential element of any crime, and it must be proved by the state beyond a reasonable doubt. That's going to be big in this case, because as far as what happened, who did it, that's no longer in dispute. Okay, Mr. Collier's not arguing that he did not shoot Joshua Torrance. Their main argument is why he did it, what was his intent. Okay, criminal intent is not an intent to violate the law, but simply means the intent to commit the act that is prohibited. Intent can be found when you find that the defendant purposely did the act. He purposely pointed that gun and shot Joshua Torrance in the back while he was running. You can find intent may be inferred from proven facts or by acts and conduct, and it may also be inferred when it is the natural and necessary consequence of the act. If you shoot in the direction of a person, as you heard Mr. Collier say, you can shoot them. You can hit them with a bullet if you shoot a gun in their direction. That's the natural and necessary consequence of that act. And you can also consider, or you should also consider, the words, conduct, demeanor, and motive and other circumstances connected with the act. Now, I laid out the indictment earlier. And when you get back there, you can consider these counts in any order you want. This is only a suggestion. When the case goes back to you, it's going to be your case after that. Okay? But I want to start with aggravated assault. A person commits aggravated assault when he assaults someone with a deadly weapon. And a handgun is a deadly weapon by operation of law. shooting Joshua Torrance with a handgun is aggravated assault. And to prove assault, state does not have to prove that an actual injury happened. Only have to prove that he intended the injury to occur. Now, if you find the defendant guilty of aggravated assault, then you would also find him guilty of felony murder. A person commits the offense of felony murder when in the commission of a felony, that person causes the death of another human being, irrespective of malice. You don't have to have malice. The only thing that's required is that the person was committing a felony and the victim died as a result. So if you find that he committed the felony of aggravated assault and Joshua Torrance died because of that, then Justin Collier is guilty of felony murder. Okay? And we also have possession of a firearm during the commission of a felony. If you find that he was in possession of a firearm, which he said he was during the commission of any of the other felonies listed in the indictment, murder, felony murder, or aggravated assault, then he's guilty of possession of firearm during the commission of a felony. And that brings us to count one, murder. Difference between murder and felony murder is with murder, the state has to prove malice, that the defendant acted with malice. Malice afterthought. It says malice aforethought, but malice afterthought. And legal malice is not necessarily ill will or hatred. We don't have to prove that Justin Collier hated Joshua Torrance, but it is the unlawful intention to kill. The unlawful intention to kill without excuse, justification, or mitigation. Malice can be either expressed or implied. Express malice is the deliberate intention to unlawfully take the life of another human being, which is shown by external circumstances capable of proof. Running somebody down over a cell phone and shooting them in the back, it's the state's position that that shows malice. He meant to do that. Malice may also be implied when there's no considerable provocation and it appears from all the circumstances of the killing show an abandoned and malignant heart. And I say all the circumstances, you have to consider what happened before, during, and after. It's all over a cell phone. And then afterwards, he just walks away like everything's okay, go home and play basketball. The very next morning, he's up doing the same thing, selling phones. You can infer malice from that, an abandoned, malignant heart. In Georgia, the state does not have to prove premeditation in order for you to prove murder. He didn't have to have planned to do this. He didn't have to, sit back and think about what he was gonna do. And the state of Georgia's up. We're also not required to prove motive. Okay, but we believe we have in this case. Running down Joshua Torrance over a cell phone, the motive was revenge. That's why he did this. Now, you're also going to be given an instruction on voluntary manslaughter. This is a lesser included offense of murder, okay? And it's the state's position that this is a murder case. It's not a voluntary manslaughter case, but because you're going to be given that instruction, I want to take this opportunity to explain that. So, to be guilty of voluntary manslaughter, a person has to cause the death of another person under circumstances that would otherwise be murder, and you have had to act it only because of a sudden, violent, and irresistible passion that resulted from serious provocation. Okay? Here we're talking about a cell phone. It has to be serious provocation, which would be sufficient to excite such a passion of a reasonable person. A reasonable person. You all are reasonable people. Okay? You're also going to be told if you find that there was a sufficient time for the defendant to have cooled off, to have calmed down, then it's not voluntary manslaughter. He's guilty of murder. And an example of voluntary manslaughter we hear a lot of in law school when we first learn about it is a situation where, couple's been married for many years, man comes home, he goes into the bedroom, find his wife in bed with another man, and he snaps her. Before he knows it, he done killed one of both of them. Now, that's not the only way that you can imply voluntary manslaughter. That's just an example. Now, you're also going to be given a charge concerning self-defense. Is also it's actually called use of force in defense of self or others, but I just shorten it. But the judge is going to tell you that a person is justified in using force likely to cause death when he reasonably believes that such force is necessary to prevent death or serious violent injury to himself or to prevent the commission of a forcible felony. And the state, when an affirmative defense is raised, the state has to prove beyond a reasonable doubt that the defendant's use of force was not justified. This is not a self-defense case. I'll talk about that more when I get back up, but that is not what this is. He ran him down, shot him in the back over a cell phone. Joshua Torrance didn't have a gun. And you're also going to be given an instruction regarding defense of property. And when it comes to using force that's intended or likely to cause death or serious bodily injury, you can only use that force to protect your property when that person has to reasonably believe that the threat or force is necessary to prevent or stop the other person's trespass or interference with property that is lawfully in the defendant's possession. I'm gonna stop there for a second because according to the video and what Justin Collier testified to, the phone was taken about 30 minutes before they met up again. Remember that? So at the time of this shooting, the phone wasn't in the defendant's lawful possession at this time. But that's one of the things you have to find. I'm sure the defense will have a different take on that, but that's one of the things you have to find in order for him to have been justified in the use of deadly force to defend the property of his cell phone. Joshua didn't have a gun. He was running away when he was shot in the back. I just thought I needed to put that there again. Now, the state's theory throughout this entire trial has been that Justin Collier acted in the spirit of revenge. Okay? That's been our only theory. And the judge is going to tell you that a defendant is not justified in threatening or using force against another person solely in revenge for something the other person said or did on a previous occasion, no matter how serious the past wrong may have been. No matter how serious the past wrong may have been. Here we're talking about the snatching of a cell phone. And That law, I believe, is rooted in our justice system. If you look at that seal, the three tenets of our system of justice is wisdom, justice, moderation. Moderation, okay? The punishment has to fit the crime, okay? So, because see, like in our country, okay, if you steal, you get to live. Okay, now, you may have to pay a debt to society, but if you steal, and that's all you're doing, you're not threatening to kill or seriously hurt somebody, you get to live. If you're out selling fake iPhones to people and you get caught, you can go through our justice system and come out alive. And then you can go and pursue other avenues. You can go in and learn real estate, okay? And experience the other pleasures of life. Get married, have children, eat good food. Joshua Torrance doesn't get any of that, okay? He doesn't get to grow and learn from his mistakes. In our system of justice, you can get a punishment, walk on, and move on with your life. That's what our justice system gave Justin Collier. Justin Collier gave Joshua Torrance a bullet to his back while he was running away. That is not okay. That was revenge. He acted in the spirit of revenge when he killed Joshua Torrance. And so I'm going to sit down. The defense is going to have an opportunity to get up and give their closing argument. And after they're done, I'm going to get back up and discuss what the defense said. Okay? Thank you very much.
I could just have a few moments, Judge. Hey, please, court, counsel, ladies and gentlemen of the jury, good morning. If you go ahead and click that side. I want to thank you in advance on behalf of Mr. Walker, myself, and more importantly, on behalf of Mr. Collier for your service. Our country only calls upon its citizens on 2 occasions to actually perform a duty. The first is military duty. Of course, we haven't had a draft in quite some time, but we certainly appreciate and are grateful for all the men and women who serve in our military and who protect us from foreign and domestic enemies here both in the States and abroad. But the other one is jury service. And when you guys responded to that summons, it allows us and affords our criminal justice system to do exactly what it does on a day-to-day basis. And so I want to thank you for your time and attention. And ultimately, I want to thank you for your patience throughout this time. I have to apologize to you in advance. You know, as lawyers, you try to do your best job that you can, right? And so at times, there may be something that I say, or there may be something that I have done that has offended you. Walker offends me every day. And so there may be something that he has said or done that has offended you. I can assure you that it's not been our intent. Our job is to represent our clients and in this case, Mr. Collier, to the best of our abilities. And we've tried to do that. And I can assure you that at no time by anything that I've said or done or the questions that I've raised, have I tried to insult anybody here. And so my hope is that when you go back in that jury room, if you're mad at me for something that I've done or Mr. Walker for something that he's done, that you don't hold that against Mr. Collier because he's kind of married to us. He has to live with us at this point. Also, you've been the witness of me and or Mr. Walker making objections. And that's not an intent to hide anything. Rather, lawyers make objections because we have to protect the record on behalf of our client. We have to make sure that we believe the state is following the rules. And likewise, the state makes objections when they don't believe we're following the rules. And so when I make objections on behalf of Mr. Collier, it in no way is trying to hide anything from you. We're just trying to do our best to make sure that the rules are followed in this case. As I told you in my opening, I thought that this case could be summed up in a couple of phrases. And the first phrase that I gave you are the same, for every reaction, there is a reaction. I think that is what has happened in this case. And of course, I've come to know and love the South. Every time I go back to Ohio, they say I have a Southern drawl. And I'm okay with that. But I've loved many of the sayings here in the South. And one of those sayings is true. And I shared it with you in my opening. You can't throw a brick and hide your hand. You just, there is something about that that makes sense and rings true when you really take a step back and listen to all the facts and the evidence that you've heard. So what I'd like to do at this point in time is kind of first go over the timeline of events that have occurred, and then talk to you a little bit about the law, and then talk to you about how you can apply the law to the facts and the witnesses who testified. And then I want to talk to you a little bit about your jury selection or your jury deliberations and the verdict form that you'll receive and how you go back and kind of deliberate with your fellow jurors. So if you can hit the next slide. So back on May, hit the next slide. This is kind of what I recall the facts and evidence. Hold me to account, collaborate with your other jurors. But back on May 30th of 2018, Justin Collier, who born and raised here in Georgia, he was in college at the time, and he was selling phones as a side hustle. Admittedly, he's admitted that there's some phones that he was selling that was fake. No doubt about it. He was trying to have a side hustle. He did it without issue prior to this date. He didn't want to go back to his mom and dad and be in their pockets. And he had bought several phones over the course of several months prior to this date. And so at or around 8:30 a.m., he gets a notification from Joshua in this case. And interestingly enough, they had both signed up on this OfferUp app. Joshua is using a fake name under Brad Williams. Mr. Collier is using a fake name under Isaiah. In any event, Mr. Collier gets a signal and a note that, hey, a guy by the name of Brad Williams is interested in purchasing the cell phone that he put up on OfferUp. It's an iPhone 8. It's a gold rose. There was a picture of it, and it's here in evidence. All of this evidence will be back with you at some point, and you can take a look at it and review it and do whatever it is you want with it to try to examine it to aid your deliberations. But at the end of the day, there was a rose gold Apple 8 iPhone Plus that he put up, and then Joshua reaches out to him about 8:30 and says, hey, look, I want to meet. I'm interested in purchasing this phone. And then even before that, before they meet at the Wendy's, they are having this exchange about the IMEI number. I may have said that wrong, but hold me to account. They're having conversations as to whether or not the phone is unlocked. All conversations that are pertinent to my client's, kind of perception and going into this, right? He's asking all the right questions at that time because this seems like a guy that is really interested in the phone. And at some point, they finally get to the Wendy's. I will say this, initially, you will see from the timestamp that the portion that was played for you, it appears that Joshua had been there for 30 or 40 seconds. State's exhibit number 2 and state's exhibit number 4, right? State's exhibit number 2 is all of the video footage of the entire Wendy's on that day, right? State's exhibit number 4 is a compilation of the video footage of the Wendy's and the CVS put together. I submit to you that if you review all of the footage from the Wendy's on that day, that it will reflect that the alleged victim, Joshua, gets there at 9:28 a.m. Because we know that Justin doesn't arrive until his car pulls up at around 9:33. I point that out to you only to let you know that the victim had been there on the scene at least 5 minutes before Justin's arrival, right? And so at the end of the day, he is there waiting on Justin to come up. And at some point, you will see, if you ask for the playing of that video at some point during your deliberations, that the victim is walking back and forth between the CVS and the Wendy's. He's sometimes standing out in the parking lot. Arguably, he's waiting on the person that he's trying to connect with, who we now know is Justin. But I will say all of that walking back and forth and arriving there so early, I submit that he knew what he was going to do already in the first place. But Justin gets there at 3. Everything is normal, right? They're having a normal conversation. They're talking about where they're from. Justin talks about being at Georgia State. The victim talks about how ultimately he had just graduated from high school. And they're talking about girls. Everything is normal when they're talking. They're talking about the phone, unlocking the phone. The victim makes a call, figures out everything is okay. And then around 9:39 a.m., after having met with Justin for about 6 minutes, Joshua grabs the phone and runs off. Doesn't pay for it. And doesn't do anything like that. And so I got to tell you, there's an elephant in the room here. It didn't come out in the state's presentation of its case. I mean, I had to really bring it out. When you go back to the opening of the state just kind of alluded to the fact that, hey, you see at or around 9:39, Joshua running away from the car. Doesn't fully embrace the fact that he robbed our client. The victim committed a crime. That's robbery by snatching. It's a crime. I had to bring it out in Detective Klein. And even when I brought it out, ultimately, the state gets back up on redirect and just points out where the shooting is. And so, by golly, I mean, the elephant in the room is that the victim was robbing Justin of his property. The reason why this is not a revenge case, this all happened in the span of 30 minutes. Kids 18, 19 years old at the time. His full frontal lobe hadn't even been developed yet, nor has Joshua's. And they're talking about, well, brighter minds and cooler minds would have prevailed, and everyone would have calmed down. Hell, if I'm 50, I probably would have called the police. I'm not chasing hell. I would have lost the race anyhow. I don't have any hamstrings after playing ball for 4 years. And so I'll say this, is that the elephant in the room is that, next slide, the alleged victim, and I say that not out of any disrespect, right? He when you think of the word victim, you're thinking of someone coming to the table with clean hands, who arguably may be an innocent bystander and catches a bullet as a result of being caught in the crossfire. That's not what we have here. And look, I'm not suggesting at any way that Joshua was a bad guy. That's not my intent. I've been doing this for 20 plus years and I've seen it all. I was the lead gang prosecutor here in this county for 10 years. And I've prosecuted so many gang crimes, it's utterly ridiculous. And so what I learned over my career, even as a defense lawyer, is that there are bad people that do good things. There are good people that do bad things. And the reality is that while Joshua robbed Justin, it was a crime. And that's something that you have to consider. You can't just isolate it in a vacuum and just look at the shooting and just ignore the fact that 30 minutes before, the victim is engaged in robbing him, right? And the reality is this is not just something that the victim did on this day. You heard from Klein that he, during his investigation, talked to friends and family members of Joshua. This is something that the victim was doing on a regular basis. Robbing people of their cell phones by using this app. There's another comment saying, you reap what you sow. And I know that that's harsh. It may be very punishing. But again, for every action, there's a reaction. You can't throw your brick and hide your hand. The notion that this was not some provocation or that this was not a serious crime, this is a felony. When you rob somebody, whether it's at gunpoint or not, it's a felony here in Georgia. So that is the elephant in the room that the state never addressed. Now, he may address it in his closing. He may come back and say why he doesn't think that it's relevant. How can it not be relevant if it happened on the same day? The shooting in this case didn't happen a day later or a week later or months later where there's some plan and thoughtful deliberation that's worked out. And at some point, we find evidence that Justin is continuing to go to this neighborhood and look for the victim because he knows that he surrounds or at least hangs out in the area of the Peaks MLK apartment complex. That's not what's going on here. That's why this has nothing to do with revenge. Is he mad? Is he frustrated? Of course he is. Who wouldn't be? If you get robbed, you're just gonna say, it's okay. You're gonna be thankful that you're still living, but are you not gonna be mad? Someone snatches your wife's purse, you're not gonna be mad? You're not gonna try to protect your family, protect yourself? Of course you are. And so I just think that when you're thinking about these things back there in the deliberation room, in the jury room, you can't just ignore this. You got to have some discussion about it, right? How does this play out? Why does this make a difference? Does it make a difference? I submit to you that it does.
Oh, yeah.
The other thing that I know that they have said it, he didn't have a gun. Next point. But it's our contention that he fired a shot. There's not a single witness now, other than Detective Kleinhans, that came in here and said, not even his sister. Yeah, he doesn't carry guns. Kleinhans, the detective, said that ultimately the crime scene was searched and no guns were found. But can I tell you this? Look, he talked about how the other detectives helped him search, and they walked the path or searched the path. But this is kind of how I got to the crime scene technician. I think his last name was Wood. When I was raising questions with him about whether or not he searched the crime scene, I pointed out the bushes by the CVS. And then I also pointed out to the left side, you had some overgrown debris, the trees. Where are they? Let me see. Okay. Sorry about that. I'm referring to states 21, right? This is a picture of the CVS, the path that you saw on the video that the alleged victim, Joshua, was running. And so if you recall some of my questions, you know, obviously he didn't document that he looked in this. And he admitted that, you know, they're kind of trained, if you don't document it, it didn't happen. He wanted you to believe that based upon his kind of routine, that's what he does. He didn't have an independent memory of looking at this. Again, this is over 5 years ago. This happened in May of 2018. Didn't have an independent memory of looking in these woods. Had an independent memory of looking in the bushes. Why is that even important? I submit to you, the reason why that's important is because, look, crime scene technicians show up on the scene and they follow directions of law enforcement, right? And they pick out evidence. Sometimes they find additional evidence. Sometimes they don't. In this case, there was no additional evidence found. There's no evidence that ultimately he searched this side. How can he have an independent recollection of searching these bushes, but not have an independent recollection of searching the other side? And what you do if you really want to find evidence and debris like that, you bring out a canine. Canines can see and smell better than we ever could. And there are trained dogs that come in on crime scenes when they're looking for things. They can see things and smell things that people can't see. Certainly, I mean, if smell's not an issue, the detectives aren't out there smelling, but they're trained to sniff out evidence. This is the very path that the victim crossed. And so I don't want you to walk back in there to suggest that I was trying to be misleading, because when I watch the video, I don't see the victim throwing something in the bushes. I point out the bushes because we had that dialogue during his testimony, because it's odd to me that he has an independent recollection of looking in the bushes, but not in this debris. And the real way to conduct an investigation is to bring out a dog. You don't leave it to air. This is too vitally important. If you want to find evidence because you suspect something, then ultimately you bring out a dog to look through the weeds to ensure you don't miss anything. That never happened in this case. And so to sit here and say that Joshua didn't have a gun, well, a gun wasn't recovered, but that doesn't mean he didn't have one, right? And what could they have done? What could law enforcement officials have done to ensure that, well, we didn't find a gun, but let's make sure he didn't fire? Because we've got witnesses saying that there were more than one shot fired. It wasn't just Arnold Durant, which he mentioned in his open close, that said that they heard shots. He indicated that he heard one shot, right? But he was also operating a very loud, compact trash machine. He was also further away from the Wendy's. The witness that heard 2 shots is Rebecca Jones. She was the Wendy's employee. She's right there. She actually witnesses the shooting. Please understand this, right? She doesn't say that she sees Justin, the shooter, who she couldn't identify because she's nearsighted. She doesn't say she sees the shooter shoot 2 times. She just says she hears 2 shots. And that's an important distinction, right? Had she saw him shoot twice, the state would have asked her. They didn't. And they didn't because they know that there were other shots fired. And let me just say this from a ballistic standpoint. The only ballistics that was recovered from the scene was a shell casing fired from our client's gun, 9mm shell casing. It was one. You watch the video, it's consistent with him firing 1 shot. So the question is, where's the other shell casing? You heard me ask the ballistics expert, been retired, worked from 1979 all the way up to, I believe it was 2012, 2013, before he formed his own kind of business. And he testified that at times you can have what is a revolver. And some of you who own firearms know this. This is kind of self-explanatory. If you have a revolver, the reality is this: the shell casing is not going to discharge. And so hence the reason why you may not find any shell casings in the path that we contend the alleged victim fired shots. And so, but what they could have definitively done to at least bring forth evidence that you could consider that the victim was not carrying a gun and didn't shoot, right? They certainly could have searched. They did search. They could have brought out a drug dog. That's one. They didn't do that, right? They didn't ask any of his friends and families whether he's known to carry a gun. You never heard any of that stuff. Of course, they don't want to ask all that because putting a gun in the victim's hands at the time is a problem for the state's case, right? And so it's like they're investigating in this vacuum. And I'm not saying that they didn't do a lot of things in the case. They got LPR readers, they got cell phone records, but as it relates to the key point that we're considering, that is whether or not he was justified in his shooting, you got to do more. You can't just say, hey, I gathered all of this evidence and I conducted this thorough investigation. But when you get to the meat and the bones and the core of the investigation, you fail in every respect. Because they could have brought a drug dog out or a canine out to sniff. What else could they have done? You saw Dr. Sullivan, the ME. She talked about, bagging and tagging of hands. The arresting agency can do it. The ME's investigator can do it. The hospital. Look, his hands were not bagged and tagged. We have no earthly idea as to whether or not there is any gunshot residue on the victim's hands right now to this day, 5 years later. We just don't know. What else could they have done? They could have submitted his clothing to the GBI. His clothing could have been submitted to the GBI to determine whether or not there was any gunshot residue primer on it. And if there wasn't, if his hands were negative of gunshot residue powder, let me tell you something. They would have been happy to have had a witness from GBI who's an expert in forensic analysis come in here and testify that, hey, let me tell you why you can be reassured that the victim didn't have a gun in this case. Because his hands didn't test for gunshot residue primer. His clothing didn't test for gunshot residue primer. We put out a dog and the dog didn't find any other ballistics other than the one found in the Wendy's parking lot. Why is this all kind of important? Because when you're robbing people out there, and everybody can use their individual experiences and walks of life, and I encourage you guys to talk about it, right? They're hard discussions sometimes back there, but ultimately everybody comes to this table and to this room and to where you guys are at with different walks of life. I suspect that some of you will appreciate that you're not robbing somebody without a gun, whether you use it or not. Because if you rob someone without a gun, you don't know what they have. And you've got to be prepared for the aftermath. It makes just sense, right? Because if you're not armed with a gun and someone comes after you and they have a gun, you just put yourself in a very deadly situation. You're not kicking in doors without a gun because you don't know what's on the other side. I submit to you that ultimately you are not robbing people without a gun. That is just a reasonable inference that all of you can draw based upon your personal experiences. As the prosecutor said, you're not back there seeking doubt, but you're not also back there ignoring your common sense, right? You are using your common sense as you deliberate about the facts and circumstances of this case. And by golly, people ain't robbing nobody unless that person has a gun. Because if you don't have a gun and you just robbing people, I can tell you right now, you're setting yourself up for something real bad. And so right now, when they say that Joshua doesn't have a gun, they can only say that not because a witness came in there and said, oh, he's opposed to gun violence and he never carries a gun. They can only say that because a gun was not found on the scene. But that's all they can say. And then ultimately, they can't come in there and say that gunshot residue, his hands were tested for it, his clothing was tested for it, a canine came out to the scene. They can't say any of that. And when he talked to you about reasonable doubt, it's a fair and impartial juror, honestly seeking the truth. It's a doubt when you're using your common sense, no doubt. But you will also be instructed, and listen to this, the instruction will say a reasonable doubt is just what it means. It is a doubt for which a reason can be given. It's a doubt for which a reason can be given by using your common sense and by considering all the facts and the evidence, not ignoring what's out there. Let me tell you something. The forensic evidence in this case, or I might add, just perhaps the lack thereof, is a doubt for which a reason can be given. And as a result, you would be authorized as a matter of law to enter a not guilty verdict on all counts in the indictment. So next slide. We're continuing with the timeline. I kind of talked about the elephant in the room, got sidetracked, probably talked a little bit more about what I was going to talk to you about later on. But in any event, at some point, Justin attempts to follow Joshua to get his phone back. Now, look, you can, when you're back there, I'm not going to play, I may play the video for you at some point. But let me go through it again. Okay, so he tries to follow Joshua to get his phone back, right? And eventually you'll see the vehicle come out of the Wendy's parking lot, take a right, and immediately to the right is the Peaks MLK apartment complex, right? He drives up in there. You heard his testimony. He finds a parking spot. He wanted to get his phone back. And ultimately, he searches for 15 or 20 minutes and can't find him, right? And so he chalks it off as a loss. Okay, I can't find him. I mean, I've looked and then I'm leaving. Next point. He decides to leave, but as he's leaving, he sees Joshua. Look, importantly, I left out of this little slide that while he's looking for that 10 or 15 minutes, he's calling him, calls him twice. The phone record's consistent with that. He testified to that. You can accept that as a fact to be true. Calls him twice. He's trying to get his phone back. But as he's leaving, after he doesn't find him, he sees Joshua in a completely different outfit. Knows that it's him, certainly consistent with Joshua disguising himself, right? And then ultimately, he confronts Joshua, honks his horn at him, is out of the car, and says, "Give me my effing phone back." And then Joshua responds and has some terse words from him. And there's an exchange, and Joshua kind of runs away and then runs away into the Wendy's parking lot, right? And then what you see is that at some point, as he's walking, Mr. Collier follows him. He wants his property back. He's not going to let it go. I invite you to ask the state whether or not even ask them, but I invite the state to tell you that it's a crime to go after your own property after it's stolen from you. That someone comes up and steals your wallet or steals your purse or steals your luggage at the airport. And I invite the state to tell you that if you go after your luggage from someone robbing you, that is a crime. I'm going to tell you that ain't no crime. And if they say it, I'd be surprised. You have a right to go after your property, period. Now, look, is it the wisest thing to do? Maybe not. But just because you make dumb and stupid decisions and don't get law enforcement involved doesn't mean that you're breaking the law. It's not illegal to pursue somebody who has just robbed you of your property. Whether the property is fake, whether it's phony, whether it was bought for $50, whether it's worth 2 nickels. The reality is that it's still your property, and anybody who robs you of your property is guilty of committing a crime. You have a right to go after your property. And so this notion that somehow or another, well, he should have just calmed down and called the police. Well, 18, 19 years old, maybe you think about that. I mean, maybe you don't think about that. Maybe you just go after it. As you get older and develop and mature, I mean, maybe you make a different decision. But just because you don't call the police doesn't mean that you've broken the law. And I will just suggest to you that, again, pulling from your experiences, and I encourage all of you to talk about your personal experiences. Sometimes when people call the police, the police don't investigate them for the crime that they're calling about, but instead they become the target of a suspect. It happens. And so it happens. Police show up to the scene. Hey, what do you, and then they start asking you all these questions. Well, what about this, and this? And before you know it, you're in handcuffs. Before you know it, you become the primary suspect. Go to the next slide. So as I indicated, Justin demands to give his phone back. Joshua refuses. Justin follows. Well, he ain't following himself, so that's a typo. Justin follows Joshua and attempts to get his phone back, and then Joshua warns, shots are fired. I want to show the video to you if I can. It's going to take me a minute to set it up, so if you can give me some time, respectfully. Yes. I can't see anything without my glasses. Video not playing. Yeah. All right, sorry about that. So I am playing for your viewing State's Exhibit number 4, the video that the state put together of all the video footage, right? I'm playing it at minute marker 17, kind of 15. And ultimately at time it's 9:39 and 43 seconds. And what you see right there is Joshua running off. Now, I want to play it in full time because I want you to really get a glimpse. If you watch as Joshua runs off, watch Justin's vehicle remain stationary for a while. Why am I pointing that out to you? You know from his own testimony that ultimately Justin says that he takes a gun with him when he feels like he's unfamiliar with the area and ultimately doesn't feel safe. And so he will take it, not with the intent to use it ever. And in fact, prior to May 30th of 2018, he had never used it. And at this point in time, you have to ask yourself the question when you're back there, if he really, if his intent was really to kill him, right? Why didn't he just get out of his car and start shooting right there? He could have. He could have done it right there as the boys running away. I want to show you another example. Same State's Exhibit number 4. I'm now forwarding it to 8 minutes. And what you will see, if you pay attention to this area up here where my cursor is circling, that is where ultimately I submit to you that prior to him coming through that cut, that is when they first have an encounter. And, Justin testified that the victim was about 15, 20 feet away. Another opportunity, if ultimately he wants, if that's what he wants, if he's not just trying to get his phone back, right? If he really just wants to, this is revenge and I'm trying to get him. I mean, he has yet another opportunity to open up his gun or pull out his gun and fire right there. Right there. He could have done it right there. Doesn't do it. And let me tell you why you can, from this video footage, appreciate Justin's testimony, right? He says that he had a prior encounter and he had words exchanged on 2 different times. First, when he's walking by his vehicle, he honks the horn. And then ultimately he says, hey, bro, give me back my effing phone, right? Dude says F you and keeps going. And you can see in what I'll play now at minute marker, whatever it is, I think it's about 8:11 right now on States 4. You will see Joshua walking at a heightened pace and looking back over his shoulder. It reflects that he had an encounter, right? So let me play that for you. Kind of trotting along right there. There he's looking over his shoulder. Still looking over his shoulder. And now he thinks he's in the clear, right? So there was a clear path if you're to believe Justin's testimony, that before the victim runs through this cut, he could have shot him. And then as he gets through the cut, Joshua was looking over his shoulder because he knows that ultimately he has an issue, that the same guy he just robbed is now ultimately, found it. And so I submit to you this, as you're thinking about time and passions, if you walk away with the conclusion that, hey, he should have let it go when his phone was robbed, which I don't think you should. It's a very short time frame. It's 30 minutes. But as he's leaving the apartment, he re-encounters the same guy that just robbed him. So I'm asking, would it not be reasonable if you see the same guy that ultimately that just robbed you to reconfront him and say, hey, give me my ish back? Of course it would be. Of course it would be. There's nothing unreasonable about that. Nothing. And so here, this video supports Joshua's testimony that he had confronted him while he was in the MLK Peaks parking lot. And then he ran through the cut, and then he follows him through the cut. And look, this is, I don't mean to turn my back to you. But this is where Justin is at now. Here is Joshua, a clear line of sight. If he wanted to really shoot him and revenge was all on his mind, why not just do it right there? Why not just take the opportunity right there? And I'll tell you, I'm a big movie buff, and I love The Untouchables. It's one of my favorite movies. Sean Connery, Kevin Costner, and it was about Prohibition. And there was a scene in the movie where these agents were meeting with some Canadian officials because they learned about a shipment of alcohol being brought to the United States, right? And the Canadians were excited. U.S. was excited, but Canadians were so excited, if you recall the movie, that they jumped the gun because they wanted all the credit to make the arrest. And as they're jumping the gun, Kevin Costner and Sean Connery, they say, oh, well, it is what it is. Let's go down and pursue. So everybody goes and pursues. There's a big gunfight. And at some point in the middle of the gunfight, right, the bookkeeper starts running toward the cabin. And Sean Connery starts to chase after him. He's got one of those long rifles, those bazookas. And, Sean Connery at that point is a little aged, if that makes sense. And at some point, he fires his gun, says, F all this running-ish, If you have a gun, you don't have to run. Bullets travel the speed of light. And I say that to you to give you the image that, why is he chasing him? If all he did was want to shoot him, why is he chasing him? He could have shot him immediately after being robbed of his personal belongings right there outside the Wendy's. He could have shot him when he confronts him in the MLK parking lot. He could have shot him when he gets to the top of the parking lot behind the Wendy's. Why is he chasing him? Is that more consistent with a guy who just wants to seek revenge and shoot somebody? Or is it consistent with ultimately an individual that wants his property back? You see, word travels on the street, right? And ultimately, if word could get out that, look, if you buy a phone from Isaiah, all you got to do is rob. He's not going to do anything. He wants his property back. He's chasing him. He's likely going to try to put hands on him. He's armed with a gun. There's no doubt about that. But at the end of the day, if you have a gun, you don't have to chase anybody. So just watch as he starts to chase. And he's chasing him even, and then he starts chasing him, looks back. Is that consistent with Justin's testimony that he said when I saw him, hey man, give me my phone back? And then they have another exchange of words. You see the victim at that point looking back, you'll be able to ask the judge and or counsel to play this during your deliberations. And while I am doing my best to kind of give you what I believe it demonstrates, the reality is that you'll have all the time back there in the world to make decisions, to review the video, and ultimately you can ask the court to watch any evidence that you want that's not back there. But I submit to you that when Justin starts to run, he is telling him exactly what he told you he told him. Bro, give me my effing phone back. The victim then looks back over his shoulder and takes out running. At this point, Justin's already running. Why is he running and he's armed with the gun? And that's what is it? I mean, look, at that point, up until the time he ultimately shoots, I submit to you, he had no intent to pull out that gun and shoot anybody. None. If he did, he would have done it on 3 prior occasions. He could have done it on 3 prior occasions. I submit to you that has got to be a part of your discussion when you're back there talking about what's reasonable. Taking my glasses off. I want to show you one other thing. Okay, so this is around 9 minutes and 39 seconds. So as you can see from this, you clearly don't see him throw anything in the bushes. And so I don't want you to think ever that I was trying to mislead you by my questions of the crime scene technician, because I was just trying to figure out how he had an independent recollection of looking in the bushes, but not one over and looking in all this debris. And this is what I think is significant about this video. So at this point, I've paused it at 9:44 on the minute mark. The CVS video does not have a timestamp watermark. I've paused it at 9:44, but now I'm going to play it. And I want you to review it, because I suggest to you that when I push play, it's still going to be frozen. And I'm pushing play now. So I've stopped it at 10:01. I mean, human error could be 10:00. Now look, we know he wasn't there for 15. I think Detective Teague said there was like a 14-second delay. I submit to you it's a little longer than that. But nonetheless, the victim is frozen for at least 15, 16 seconds. And then here's the important part, right, that you have to consider in your analysis, is that when it becomes unfrozen at the 10:00 mark and the 10:01 mark, you don't see him continuing to run such that you can see if he discharges a weapon or anything like that, right? You see him disappear from the screen. Now that is a glitch in the computer, but at the end of the day, That's not his fault. That's not Mr. Collier's fault. And I submit to you that shots were fired at that time by the victim in this case. And that is a doubt for which a reason can be given by using your common sense. Not only because our client testified to it, but also because all of the supporting evidence, there's no other objective evidence to support the fact that he didn't have gunshot residue on his hands. We don't have that evidence because the state didn't produce it. Again, this is their burden. It never shifts to this side. It's their burden. It's also their burden to prove beyond a reasonable doubt that he was not justified in shooting. That's their burden to disprove that he was not justified, not his burden. And look, I'll tell you, he testified. He didn't have to testify. Wasn't required to testify. The law doesn't require it. A defendant has an absolute right to remain silent, and had he not testified, the court would have instructed you that you can't use his silence as a means to, as a hang up back there to use it against him. You can't use it against him. He testified. And I want to talk to you a little bit about his testimony because at some point he was also cross-examined. First, I want to talk to you about the certified misdemeanor conviction of theft by deception that was introduced on cross. I mean, look, I get that they introduced it and they want to try to impeach him all day long. He said yeah, I did that. That's number one. But the notion that you're introducing deception and trying to discredit him, but not embracing the victim doing the same thing, robbing people of phones and then putting it back up on offer up for $450. It's in the records. I mean, the victim put it back up on offer up for $450. And so it's kind of like, you're trying to make him look bad because this is what he does, but hell, the victim is doing it too. And so I just don't think that in this grand scheme of things is at issue or play, because it's not like he denies it. He admits to it. Yes. I mean, sometimes, in fact, on his direct testimony, he said sometimes they were fake phones. I wasn't really worried about that, is what he said. I was worried about whether or not the phone was operational and whether or not I could make some money off of it. So I submit to you that in the grand scheme of things, that misdemeanor to which he pled for and got probation is not really something that discredits him. Talk to you about the jailhouse conversation where he said, yeah, I didn't do anything. I'm innocent. He knows that they're being recorded. There's a recording that comes over the phone in the system saying that all the calls are being recorded. All of his family members and friends know that. The second call, his friend is jokingly, yeah, you didn't do anything because you were with me trying to create an alibi. I mean, no. I mean, I'm not saying that people don't talk recklessly over the phone, but in the grand scheme of things, at the end of the day, he told you he knew it was being recorded. He didn't want to expose himself. Now, he shouldn't have been talking on the phone about the incident. Sure. But at the end of the day, does that really have anything to do with what happened on that day in question? I submit to you it does. And if that's the only thing that the state is relying upon, come on. They got to do better than that. They should want to do better than that. And so let me try to get back to my power slide. What's my time, Judge?
I think we're right under an hour.
Okay, I'm trying to wrap it up.
56 minutes.
Okay, thank you. So the indictment in this case charges him with murder, felony murder, aggravated assault, and possession of a firearm with a deadly weapon. You can go to the next slide. I want to talk to you a little bit about the law. I know it's already, he's kind of talked to you about it. I think he's fairly and accurately kind of summarized the law. I will say, you know, pay special attention to the reasonable doubt instruction that you get. It's going to tell you it's a doubt for which a reason can be given, not some vague and arbitrary doubt, but a doubt for which a reason can be given. Go to the next slide. And importantly, you guys will have these instructions back in the jury room with you to aid your deliberations. And so if you're taking notes on the instructions, the reality is that they'll have, you can always refer to them while you're deliberating. And if a point comes up about what is murder, what is felony murder, or what is justification and voluntary manslaughter, you can just look at the charging instrument that the judge will instruct you on and then send back with all the evidence, if that helps. And so, but you as the jurors, there are two jurors in this case. There's two judges in this case. There's the judge who presides over the law. He kind of is the gatekeeper of evidence. He essentially serves as a referee, if you will, between the parties and to make sure that the process is fair to both sides. But you guys are the most important judges in this case because you guys are the fact finders. And you have to sift through the wheat and the chaff and all of the evidence that has been presented. The witnesses, the physical evidence, the video footage, and you have to make findings of fact of what you believe happened in this case. As it concerns witnesses, you can go back, please. There you go. So you're the sole judges of credibility, the manner in which they're testifying, their intelligence, their interest or lack of interest in this case, the means and opportunity of knowing the facts. Consider all the facts, right? And so I will submit to you going back to the witnesses who heard shots, because you only heard two witnesses testify that heard shots. Now, there was Mr. Clemens, I think it was Calvin Clemens who testified. He worked at the apartment complex as well. Ultimately, he just found the body. He didn't testify that he heard shots. I mean, that's my recollection. The only two people that talked about shots being fired or hearing shots is Arnold Durant and Rebecca Jones. And again, I've talked to you a little bit about that already because I got off script, but Mr. Durant was working very loud machinery, the compact tracks. He says he hears one shot. The person who is closer to the shots and actually sees the shooter, sees Justin, is Rebecca Jones, and she says she hears two shots. So where is the other ballistics? And she didn't say that Justin shot twice or that the shooter shot twice. She just says she heard two shots. Where is it at? Okay, keep going. So he's talked to you a little bit about murder. There are two ways to charge murder in Georgia: malice murder and felony murder. No matter how you charge it, the reality is this. Next slide. Murder. It's not like degrees, like first, second. You watch Law and Order, and you get second murder and second degree murder. It's not like that. Next slide. Murder it's a killing without justification, excuse, or mitigation. That's what murder is, without justification, excuse, or mitigation. Justification is simply a defendant is justified in using force against someone else, right? If the force is intended or likely to cause death or serious bodily injury, if one, he reasonably believes that the use of force is necessary, and two, to prevent death or serious bodily injury to himself during the commission of a forcible felony. What is the forcible felony that we contend happened in this case? It wasn't necessarily the snatching of the phone. It was when the alleged victim shot at him. That is the forcible felony. And when you get shot at, the law authorizes you to defend yourself. and to shoot back, period. Second one, defensive property. Mr. Lee talked about it. It's a little slightly different, but very similar. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury against someone who intentionally interferes with their use of property when reasonably believes that the force or threat is necessary to prevent or stop the other person from the interference with the property in the defendant's lawful possession. And at the time, he reasonably believes that such force is necessary to prevent a forcible felony, right? And so when he doesn't shoot at the time the phone is snatched, he exercises restraint, right? Not so much a forcible felony that would otherwise justify a shooting. But when you're shot at while you're pursuing the very property that was stolen from you, and you're shot at, that's the forcible felony in which you are justified to shoot to defend your property. Again, following someone to get your property back is not unlawful. And while you're doing it, the person who stole your property can't then shoot at you and claim that, oh, you weren't justified in shooting back because you had a right to get your property in the first place. Next slide. So there's murder, there's felony murder, and then there's a lesser included voluntary manslaughter, right? And I know Mr. Lee has talked to you about it. I think he appropriately summarized it, but I'll just do it again. Again, you'll have it back there for your review. The evidence must prove that the defendant caused the death of another person. We don't dispute that, right? We're not disputing that he died from some other natural cause or from some coronary artery disease, or he died, he would have survived this gunshot wound, but for some other serious medical condition. The gunshot wound, according to Dr. Sullivan, we accept that to be true. We never challenged that testimony. Ultimately, the gunshot wound that he shot caused the death of Joshua Torrance. Under circumstances that would otherwise be murder, sure. If he just walks up and shoots Joshua when there are no other facts or circumstances, it would be the unjustified killing of another human being. I mean, murder is essentially the unjustified or intentional killing of another human being without provocation, and then acted only because of a sudden violent and an irresistible passion that resulted from serious provocation. Well, look, I mean, they tried to suggest that the serious provocation was not the snatching of the phone. I will submit that ultimately, when someone is robbing you, that's pretty damn serious, right? However, we got more than that. We've got other shots being fired, or at least one additional shot being fired that's unaccounted for. And we submit that the evidence has established that it was the victim who was shooting. And they can't disprove that the victim wasn't shooting. They can just come up here and say, hey, we didn't find a gun. And then which was sufficient to excite such passions in a reasonable person. Well, anytime you shot at, of course. Of course. And so I will say this. We submit that he shouldn't be found guilty of murder or felony murder or voluntary manslaughter because he was justified in the shooting. If you find that his shot was justified, you have to, as a matter of law, find him not guilty. And so while we're going over these charges, the reality is that we're just going over them for your consideration and your deliberation. And importantly, it's important to know this. He's also charged with aggravated assault, right? And so aggravated assault is tied to the felony murder, right? But ultimately, you have to figure out murder, felony murder, but you could find that he's not guilty of either one of those. Because if you find that he's justified in shooting, then ergo, he would not be guilty of voluntary manslaughter and or aggravated assault or using a deadly weapon during the commission of a firearm. Next slide. Witnesses, I've kind of gone through all of them. I said 2 fact witnesses, really 3 fact witnesses. His sister, Arnold Durant, and I think Rebecca Jones is coming up. Next slide. Of course, I didn't leave in Clemens there. He did find the body. We had law enforcement officials testified. Investigator T, he collected the video. crime scene tech Wood, I've already talked about him, and then Detective Kleinheinz. I may have misspelled it, but ultimately, let me just say is that he concluded from his investigation that Joshua robbed our client. What he also concluded, and I had to get out with him through all of his affidavits where he appeared before a magistrate judge and took an oath and swore to a magistrate judge to get probable cause to search various things to help him with this investigation, was that ultimately his investigation determined that this was the victim's MO. He had been doing this based on information from family and friends. This was his MO. Keep going. Of course, I talked to you about Justin Collier's testimony. Look, there was another issue about him going to eat and play basketball after the incident. I submit to you that he didn't know that he killed the young man at the time. And he kept running. He drove back through that area, although he doesn't remember driving back through the area. I mean, the reality is that, he kept running. There was another incident. Well, where's the gun? He said it got stolen from him. When I say you reap what you sow, it doesn't just apply to the alleged victim, it applies to Justin too. Been selling phones and fake phones and all that stuff. And then all of a sudden he meets up with a person with his gun on his person and sells him a phone, gets $600 for the phone. And then the guy sees the butt of the gun and ultimately says, hey, I'm interested in the gun too. And this, he gun is loaded and says ultimately, he says he's going to give him $900 for the gun. He bought $300. Bought it for $300. It sounded like a good business decision. He's making $600 on the phone. Why not give it to him? And then ultimately the guy gives him $1,500, $6 for the phone, $9 for the gun, and ultimately turns the gun on him. Doesn't put up a fight, lets it go, lives to see another day. But he reaps what he sows too. He got robbed. He could have got killed that night. Of course, I said you don't have to run with the gun. I think all of the video evidence reflects that. And he had 3 different opportunities had a clear line of shot to shoot the victim. Didn't do that. It's chasing him. Keep going. All right. So deliberations. You guys have to go back there and eventually the judge will instruct you to select a 4-person, right? And so when you select a 4-person, that's just a person that has no more weight than you do. It's just the person that is designated to communicate with the court in the event that you have questions, right? And the 4-person will try to, sometimes things back in the jury room get heated. And what they say is what happens in the jury room stays in the jury room. It's like Vegas, but eventually you'll select a 4-person and then ultimately you will start your deliberations. And how you conduct your deliberations is, how you see fit. There's no one way to do it, but I submit that you take a stab at discussing the facts and evidence as you have heard from the testimony, and then ultimately try to reach a decision. Here's what I will say about deliberations. It's so important, again, that everyone here is walking from all walks of life, coming from all walks of life. And that's what makes the system of our criminal justice system so great. Because people who don't even know each other can come together and ultimately make decisions and find facts and try to reach a decision. And because we come from all walks of life, it's so important to respect each other's opinions about those walks of life and what their experience is. But I will say this, as much as you respect your fellow jurors during your deliberation process, as young as you are as a juror, the reality is this. You don't ever have to surrender your opinion simply because someone else disagrees with you. You don't ever have to surrender. And the judge will talk to you that your verdict has to be unanimous, right? But that is not an instruction that forces you to stay back there until you all agree. That's not what that instruction means. It just means as a matter of law, in order for it to be a valid verdict, everybody has to agree. There are times that jurors don't agree. And sometimes that's just what it is. And my hope is that you do agree. My hope is that you are able to reach a verdict and ultimately sift through all the evidence and consider the verdict form, which I'll go over with you in a few seconds, and you're able to reach a unanimous verdict. But let me just say this, if you don't all agree, and some of you are back there and saying, well, I feel like he's guilty based on the evidence, and some of you are, I feel like he's not guilty. The reality is that you never have to surrender your guilty verdict or your not guilty verdict simply because your jurors disagree with you. You don't even have to compromise. Well, let's compromise on something. Let's try to compromise. Maybe we can do the lesser included. Let's compromise. You don't, that's not what you're authorized. I mean, that's not what you're, I mean, I guess you could compromise if you wanted to, but you're not required to compromise for the sake of reaching a unanimous verdict. This case is too important to the state. It's too important ultimately to Mr. Collier. And so if at some point you're finding that you're in disagreement, you don't have to ever surrender your opinion. Now, what I will tell you is that you still have to kind of deliberate. You know, you just can't go back there and say, whatever, I'm not deliberating. I've made up my mind. I'm not interested in talking to many of you. Because what will happen is that jurors will send out a note to the judge, and then we'll have a whole bunch of meetings, and we'll try to figure out who's not deliberating, and then you'll be axed out of the process. You X'd out of the process. And so to the extent that you disagree with your fellow jurors, doesn't mean that you don't deliberate with them, doesn't mean that you don't listen to what they have to say and challenge what they say, and then ultimately they challenge what you say, and no need to get offended about any of that. The reality is that people just sometimes can't reach a unanimous decision. I want to talk to you about the verdict form. So I don't have it in my PowerPoint presentation, but this is the verdict form that you'll get back with you. So count one is related to the voluntary manslaughter. You have to consider that first. And then it says, or malice murder. That's count one, right? And the reason why you have the under count one, you know what I mean, voluntary manslaughter and murder, you're considering those charges, is because voluntary manslaughter is a lesser included of murder, right? And so you have to consider both of those when you're considering the first count in the indictment, which is malice murder. Did he commit murder? If you say no to that, then you have, consider whether or not he committed a lesser included voluntary manslaughter. If you say no to that, then you've authorized a not guilty verdict on both of them. The same is true with felony murder, right? You have to also consider ultimately voluntary manslaughter, okay? So voluntary manslaughter is a lesser included of felony murder. It's important. The reason why I share that with you, and I'm going through this form with you, is because the third count is aggravated assault with a deadly weapon. It doesn't have a lesser included. Aggravated assault with a deadly weapon, voluntary manslaughter is not a lesser included of aggravated assault. But while you're considering felony murder, if you believe, for example, that it's not felony murder, but it's voluntary, then by virtue of you saying that he's not guilty of felony murder, you are also saying that he is not guilty of aggravated assault with a deadly weapon. And finally, obviously, possession of a firearm during the commission of a felony. That's just, he's using a gun during the commission of a felony. That's a sole count. And if you feel like his shooting is justified, you have to enter a not guilty verdict. Let me just show you. Look, I've marked it up, and not that you have to accept my word. Those are all not guilty verdicts, right? On all four counts in the indictment, right? It could be that you disagree with me, and I don't think you should. I don't think the evidence and the facts have ultimately panned that out. I don't think the state has met its burden, and it's even if you think that he's guilty, right? Even if you think that he's guilty, if you feel like the state hasn't met its burden and you still have doubt, not that you're seeking doubt, but you still have doubt because of the lack of evidence that they've presented. The reality is this. I mean, you still have to submit a not guilty if you don't feel like they carried their burden. Now, you could disagree with me and say, okay, I don't believe that this is murder or felony murder, but I do believe it's voluntary manslaughter. And so your verdict would look different. I mean, it would look that you would say not guilty on murder, you would say not guilty on felony murder, and then you would just change these two and you would put guilty on voluntary manslaughter. And so I have to leave you with this. This is an incredibly sad case. And you got two young men who have made decisions within 30 minutes, some would say seconds, that has altered their life. And so it's not lost on this table or Mr. Walker or Mr. Collier that Joshua lost his life. And my condolences go out to the family. I couldn't imagine. But I will say is that notwithstanding that, you also have a young man's life in your hands. And under our Constitution, he's entitled to a fair process. And he's entitled for all of you to go back and discuss this case with your fellow jurors and decide ultimately on the charges in this case. Be fair to each other, be reasonable. And I just want to thank you for your time and attention, but I believe that after you go through all the facts and the evidence, you will find my client. I'm asking you respectfully to find my client not guilty on all the charges. Thank you for your time and attention.
Before we proceed with the state's concluding argument, does anyone on the jury need to stretch break in place or a lengthier break? The second?
Quick break.
All right, let's take 5. We'll be back in 5.
All right, the jury.
He used 23 minutes. So the answer is a lot.
Ooh. 25 sticker that was on the floor. I'm not sure.
All right, for jury.
All right, thank you, everybody. Mr. Lee, you may proceed.
So I took a few notes when Mr. Banks was giving his summation. I just made note of 3 things that I'm going to talk about before I get into what I wanted to talk about. But Joshua's not a victim, and you reap what you sow. That's, believe they raised that in the context of their theory of self-defense. And I'm going to get into that in a second. But this third one, that because he shot Joshua on the same day, this can't be a revenge case. That is absolutely false. Okay, the statute, the instruction you're going to get says that you cannot use revenge. You cannot take revenge when someone does a prior wrong on a previous occasion. That's all it says, previous occasion. It doesn't say, 24 hours have to pass or anything like that. This is absolutely a revenge case. And Justin Collier was not justified in shooting Joshua. This was not self-defense. Joshua did not have a gun. And there is no evidence suggesting he did, other than the only evidence that Joshua had a gun came from Justin Collier. He's the only one that says, I saw Joshua shoot a gun. Okay. And so you would have to believe that evidence. Okay. And we have to disprove it. Now, there was this talk about, well, there could have been a gun in the woods, and they didn't bring out a drug dog. That hasn't been established. You all took notes. What I recall the testimony being, the question was asked of Wood, crime scene tech Wood, did a drug call? Did you see any crime canines come out? And his answer was, I don't recall. Okay. He never asked Detective Kleinhans whether or not he called out canines or not. And he came up here twice to speak, specifically when asked about if Joshua had a gun or not. That's why I brought him back up in rebuttal. What they both said is, we searched the evidence and collected all relevant evidence we found. They found one shell case. One shell case. They didn't find any guns on Joshua's person. They didn't find it around him. They didn't find it in the path he ran. They didn't find it in his book bag. They didn't find a gun. There's nothing on the video suggesting that he had a gun. He didn't have one. Now, there is a conflict in the evidence regarding the number of shots. One shell casing. Arnold Durant says he heard one shot. And I recall Hannah Jones saying she heard about 3 or 4 shots. That came out on cross-examination. Mr. Banks said, I came to your house and you told me there was about 3 or 4 shots. Refer to your notes. That's what I remember. Now, regarding Hannah Jones, it's important to consider her perspective. Okay, she was witnessing a traumatic event at the time it happened. She's seeing this shot that there's a customer outside, and she's trying to get him in. It's our theory that she is simply mistaken as to the number of shots because there's no physical evidence corroborating that. There was one shell casing found. And this thing about the movie quote around, well, dang all that running, I'ma just kill him. That works the other way around too. If you recall, when Joshua started running, he was a great distance away from Justin. If he had a gun, if he wanted to shoot his pursuer, he didn't have to start running first. He could have simply pulled out this gun and started shooting, but he didn't do that. He ran full speed, focused on where he was going. He didn't have a gun. He was running away from this defendant. He ran full speed. How in the heck is he going to run full speed and then be able to shoot? Just fire some blind shot. Why do that? Why even do that? Because he's not catching up. He is way gone. He is the one who said, damn all that running, because he wasn't going to catch him. Joshua was way ahead of him. Justin said, damn all that running, and that's why he pulled out that gun and shot him in the back. And so, and then the suggestion that, well, it could have been in the woodlines, and I'm gonna play the video in a second. Just remember what's happening, okay? If he had a gun and he shot, why is he gonna take the time to
black man that's trying to kill the black man? And when he has, and the defendant.
So. And that's been, look how far he is away from him. All he has to do is turn around and shoot then. If he wants to shoot his pursuer, he could have done it right then. His conduct has been running. When he snatched the phone, he ran. He never had a gun. Look, he's not looking, he's getting it. He's getting it. Here's Justin, just walking back. Like nothing happened. I'm gonna talk more about that in a second. Goes by the police, goes the wrong way through the drive-through. Then look at he's getting it. And by this time, where it freezes, he done passed all these woods that Mr. Banks is saying, you know, Mr. Wood is you know, there's something fishy about him not remembering if he went all up in there or not. He's not throwing anything away. He is running for his life. That's how he responded to the threat. He didn't respond to the threat by shooting him. He responded to the threat by running for his life. All right, you can stop playing the video. He was shot in the back while running away. He was shot in the back while running away. He wasn't armed. He didn't fire any shots or anything like that. He was shot in the back while running away. This is not a self-defense case. And he's guilty of murder, not voluntary manslaughter. I want to talk about that. There was no serious provocation. There was no gun, so I've covered that enough. But the only other way there could have been one is over this phone. He took the phone 30 minutes before and said F you when they met back up. That's not serious provocation. And if you recall on direct, the defendant says, well, no, I wasn't. When I was looking for the phone, when I parked the car and walked around the complex, wasn't that mad. I wasn't that mad. So according to him, it's, you know, his defense is self-defense. He's not claiming it was voluntary manslaughter. And for there to be, for the snatching of the phone to be the provocation, you have to consider that in the context of he's also a thief. He's also a thief. He's going around selling stolen iPhones to people, but that's supposed to be, but when it happens to him, oh my God, it's so serious, I just snapped. No. Remember, you know, he's, you know, well, I sell a lot of phones, and if somebody buys a fake one, then that's just on them. So to suggest that there was serious provocation over the phone, that's not serious provocation. He knows he shot somebody. This theory of I didn't know No, I shot him. He knew. And that's why he walks after he shoots, and he's just walking calmly as if nothing happened. He's trying to avoid drawing attention to himself. Okay, this whole because he can't have it both ways. Well, I'm not about that life. I bring this gun to these serious situations. I get shot at for the first time, and I just walk calmly back to my car. That's inconsistent with common sense. That's inconsistent with common sense. If this is the first time something happened to you and you got shot at, you're trying to get out of there the fastest way you can. You're not walking back to your car calmly. You're running back to your car so you can hurry up and get away, especially if you believe him where he says, well, I don't know where he went. You're not trying to walk back to the car all calm when this is the first time in your life you ever been shot at and you're not about that life and all of that. No.
We approach.
All right. Mr. Lee, you can continue. The jury will recall the evidence that was presented.
He knew he shot somebody. He's covering his tracks. He's avoiding drawing attention to himself. He doesn't call 911. He doesn't flag the police down that or nearby. Don't do that again. Go ahead. Now, and some of this I've already, and when we're talking about voluntary manslaughter, what voluntary manslaughter implies is that you come under this sudden, irresistible passion to kill. You're doing something you wouldn't normally do. Okay? You snap. So it necessarily implies that at some point you got to come back to reason. Okay? What this defendant does is after he shot somebody, okay, he goes home, gets something to eat, still doesn't call 911, and plays basketball. That is not the actions of someone who acted under a violent, sudden impulse. Okay? It's not, this isn't a voluntary manslaughter case. This is murder. Now, and then he got rid of the weapon. He definitely did that. He's pulled over the next day, and there's a Glock firearm box in the thing, in a car with no firearm. He just says, I left it over my girlfriend's house. Now, and there's only two conclusions you can draw from that, I submit. Either he got rid of the gun, or you actually believe that story he told about somebody robbing him for it. So I want to just take you back to that testimony. And again, and consider that testimony along with everything else he said when you're deciding whether or not to believe him when he says that he saw Joshua shoot a gun at him. He said that the day after, he chose not to bring his gun with him because of what happened before, the shooting that happened before. So he said, I'm not going to bring my gun with me because of what happened before, but I'm gonna go and sell phones again. Even though on the previous day when I sold phones, I got robbed and somebody shot at me. This time, because of what happened, I'm not gonna bring my gun. I'm not gonna bring my protection, even though I had to use it the previous day. Okay. And then he says, well, also because I was selling it downtown near Georgia State, so I feel safe there. So I wasn't gonna bring it. Okay. And then he says about 4 days after that, he's selling another phone at Georgia State, but it's in an unsafe part of the Georgia State campus. So he decides to bring his firearm with him on this occasion. And then the person he's supposed to sell the phone to says, okay, well, let me buy your gun too. Now, this is 4 days after he had to, according to him, use this gun to save his life, okay? He says, I give him the phone and the gun. I give him the phone and the gun to some stranger because I'm young and naive. And then he turns the gun back on me and robs me. That doesn't make any sense. You have to believe that's what he told you. When you decide whether or not you believe him, remember that. That is absolute hogwash. Now, let's talk about these jail calls. Okay, when he's talking to his friend at the jail, I'm innocent. I didn't shoot nobody. Okay. And then on the other call is, I didn't do X. I was with you. And then he testified at trial. Oh, well, I only shot because he shot me. It was self-defense. Both can't be true. Both can't be true. He either lied to them or he lied to you. He already lied to you when he told you that crazy story. He is lying. And there is no evidence to support that Joshua had a gun. There just isn't. It's on video. It's on video. And he's running at full speed. There's no way he had a gun. Don't let him hustle. Because that's who he is. He's a hustler. That's what he did. And there was no self-defense about it. He's a hustler. So that's what he did. Joshua Torrance was 18 years old. And so what if he snatched the phone? So what? That does not give you the right to run down an unarmed 18-year-old and snatch his life away, shoot him in the back over a phone. It just does not. So please go back there, consider the evidence, consider all of it. And when you do that, I'm confident that you will return a verdict that speaks the truth. And that is that Justin Collier is guilty of murder, felony murder, aggravated assault, and possession of a firearm during the commission of felony. Thank you very much.
All right. Members of the jury, we've now reached the part of the trial where it is my job to charge you on the law that applies to this case. This process takes some time. I would estimate 15 to 20 minutes. You will receive a written copy of these instructions along with the exhibits and other evidence that we are allowed to give to you back in the jury room. You are considering the case of the state of Georgia versus Justin Collier. The grand jury has indicted the defendant with the offenses of murder, felony murder, aggravated assault with a deadly weapon, and possession of a firearm during the commission of a felony. You will be provided a copy of the indictment during your deliberations. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with the presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charge beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the doubt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration of all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence presented. Then you must apply the law I give you in the charge to the facts you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and the exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch, and may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but must also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit, and if so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury to decide. The jury must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. The credibility of a witness may be attacked by disproving the facts to which the witness testified. In determining the credibility of witnesses and any testimony by them in court, you may consider, where applicable, evidence offered to challenge the credibility or believability of any such witness. And this would include evidence of proof that the witness has been convicted of a crime involving dishonesty or making a false statement. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant in the criminal case may take the stand and testify and be examined and cross-examined as any other witness. You should evaluate such testimony as you would that of any other witness. However, the defendant does not have to present any evidence nor testify. This defendant is charged with a crime against the laws of the state. A crime is a violation of the statute of this state in which there's a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may, in your discretion, be inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. The defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of the words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the products of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference is a matter solely within the discretion of the jury. The law provides that criminal action shall be indicted in the county in which the crime was committed. In a prosecution, in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, the crime was committed in Fulton County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offense. Venue must be proved by direct or circumstantial evidence or both. For malice murder, the state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation, and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in an instant, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault with a deadly weapon is a felony, which I'll define for you shortly. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault with a deadly weapon, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. In considering the malice or felony murder charge, You must decide whether the defendant was sufficiently provoked or acted out of passion. If you find this, you may not return a verdict of guilty of malice or felony murder, but you would be authorized to return a verdict of guilty of voluntary manslaughter. The state must prove beyond a reasonable doubt that the offense should not be reduced from murder to voluntary manslaughter. For voluntary manslaughter, the evidence must prove that the defendant, 1, caused the death of another person, 2, under circumstances that would otherwise be murder, 3, and acted only because of a sudden, violent, and irresistible passion that resulted from serious provocation, and 4, which was sufficient to incite such passion in a reasonable person. If you decide that enough time passed between the provocation and the killing for a reasonable person to have cooled off and regained judgment, then the killing is not voluntary manslaughter. For aggravated assault, the state must prove that the defendant, 1, assaulted another person, 2, with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. For possession of a firearm during the commission of a felony, the state must prove that the defendant, 1, had a weapon, 2, on his person, 3, while committing a felony that is a crime against or involving another person. Murder, felony murder, and aggravated assault with a deadly weapon are felonies. The term firearm includes any handgun. Sometimes a defendant's threat or use of force is legally justified, and so is not a crime. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury when, 1, he reasonably believes that the use of such force is necessary, 2, to prevent a death or serious bodily injury to himself or a third person, or the commission of a forcible felony, which means a felony that involves the use of force or violence against another. The state has the burden of proving beyond a reasonable doubt that the defendant's actions were not justified. If you decide the defendant's actions were justified, then it would be your duty to find the defendant not guilty. A defendant is not justified in threatening or using force if he provokes the threat or use of force against himself, intending to use that threat or force as an excuse to harm the other person, or is the initial aggressor unless he withdraws from the encounter and clearly communicates to the other person his intent to withdraw, and the other person continues or threatens to continue the use of unlawful force. A person who is not the aggressor is not required to retreat before being justified in using force he reasonably believes to be necessary. Sometimes a defendant's threat or use of force is legally justified, and so is not a crime. A defendant is justified in threatening or using force that is intended or likely to cause death or serious bodily injury against someone trespassing on or otherwise intentionally or negligently interfering with property only when he reasonably believes that the threat or force is necessary to prevent or stop the other person's trespass on or interference with property that is lawfully in the defendant's possession, and the defendant reasonably believes that such force is necessary to prevent the commission of a forcible felony. A forcible felony means a felony that involves the use of force or violence against another. Property means land or any structure on it other than a residence or place of business, and personal property other than a motor vehicle. The state has the burden of proving beyond a reasonable doubt that the defendant's actions were not justified. If you decide the defendant's actions were justified, then it would be your duty to find the defendant not guilty. A defendant is not justified in using force against another person solely in revenge for something the other person said or did on a previous occasion, no matter how serious the past wrong may have been. If you find beyond a reasonable doubt that the defendant used force against the alleged victim for the purpose of avenging a past wrong and not for the purpose of preventing an imminent use of unlawful force, death, serious bodily injury, or commission of a forcible felony, then you would be authorized to convict the defendant. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt the defendant in Fulton County, Georgia, did on or about the 30th day of May, 2018, commit the offense of murder, felony murder, aggravated assault with a deadly weapon, and or possession of a firearm during the commission of a felony, as alleged in the indictment, you would be authorized to find the defendant guilty of that offense or offenses. And in that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of an offense, or you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. By no ruling or comment that the court has made during the progress of the trial, has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict should be a true verdict, based upon your opinion of the evidence according to the laws given to you in this charge. You should not show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic status, for or against either party. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourself with punishment. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous, that is, agreed to by all, and the verdict must be in writing and signed by one of your members as foreperson, dated, and returned to be published in open court. Shortly, we'll ask you to retire to the jury room, but remember, do not begin your deliberations until you receive the indictment and any evidence that we are able to send to you in the jury room. All right, so I'll ask juror number 37 to stay behind. As for the remainder, you may now retire to the jury room. All right, juror number 37, you may have gathered that there are 13, and you're the odd man out for now as our alternate. But what we are going to ask you to do is we still want you to take advantage of the lunch that we have if you'd like to, or you can break for lunch and have your own schedule. But if you leave the building, please remain within contact. But until we excuse everyone for the day, we would ask you to still be with us. We'll now have a separate space for you. We have a conference room next door to the jury room, and we would ask that we use that area as your time until we see whether we may still need you. And as you're back there, we'd ask that you not interact in any way with the rest of the jury if they take a break or if you see them out in the hallway. Understood?
Yes, I have something in the room, right? Pick it up now and.
Yes, why don't you accompany the deputy and he'll get that for you. And then he'll also show you where that conference room is next door. Thank you, sir. Well, let's first do this before I forget. Any objections from the state as to the charge to the jury?
No, yeah.
Any from the defense?
No, Judge.
All right, I had told them yesterday that it's up to them.
Okay.
So the deputies can let us know, and if there's communication, they know how to get it to us. And if everyone could stay within 10 minutes or so of the courtroom, we'll let you know when we get any communications from them and how things are going. Anything else?
I think Ms. Borders has my cell phone number. We may walk to get lunch, but.
I might still have it. I don't know. I'll take it. I'll take a card though. All right, we'll be in recess.
Everything goes to that with the exception of that.
Yeah, of course. Yeah, of course. I mean, I would take your time.
Yeah.
Yeah, I think they're gonna. And definitely if you can mark the time whenever we
Sure.
take all that down.
Yeah.
Then let me know.
Yes, sir. I am, I'm grabbing him. The verdict one. Sure.
Yeah.
Said the other party was here.
Huh?
He said the other party was here. Said the other party was here.
Okay, they are aware that you filed something, okay?
So what?
They are aware that you filed something. So you would just still have to wait until whatever decision is made, okay?
You know how long that will be?
I have no idea. Okay,
Thank you.
you're welcome. You remember the other guy? Mm-mm. I'm good. But you remember the other party that was just here, the guy? He was here for that, the civil matter. Hmm? Yeah.
So what they do is they look at the account, and you see the dollar value go down, right? So when you see the dollar value go down, they get out. But when they get out, that means they had to sell their share to get out, right?
Mm-hmm.
Like the bishop and judge during that other one, okay?
Everything was smooth. Yeah. That's what I was telling my nephew outside out there. If you can't control yourself, stay outside. You know what I mean? And I stopped it. I did speak to the family, young family. Yeah, I did speak. You know, people, I was watching this young lady here, this young girl. She's hurting. And people don't stop to think about it's not making us bad, see. Right? You think they're doing just fine. All of a sudden, the decisions that they make is really affects everybody. It is not just them, it affects everybody. But the emotion aspect of it is I tell them, saying, you forgive the person, right? You can forgive that person, but it doesn't take away the consequences that they have to face. That's the faith where it is. See what I'm saying? And it's not going to affect just this. It's unfortunate. Don't know that. Another thing that, I was thinking, it's like this young man, nephew, and people get out on these different websites. Yeah. These quick businesses, right? They start transacting perfectly. Everybody, what's wrong with you?
Same type of person.
So, years ago, my brother-in-law and his neighbors told me my wife had married. We were in the house, right? His neighbor introduced me. His neighbor had a satellite dish in his house. He wanted to sell it, big satellite. And we offered the service. So what do you want to do? I buy it. I said, well, in order for me to make this transaction, I would have to go have you down to PPV. And we're gonna track on this, you will see the story. And he agreed. When we came back, and we walked in, standing there, we wanted to track on this unit, determine whether or not this is a story. Make sense? And once that was done, they gave a report stating that it was not stolen. You see what I'm saying? Who was up there? Isn't that interesting? Now, if you wanted to sell it, he would have said, okay, if you didn't want to sell it, under this condition, I was prepared to let him say, keep it. Right. So my reputation means up to you. See? Not next week. You gotta make it now. So, talking to the students, and telling the students, I'm not sure. In temporary, you are now moving to that area called moving. Called walk. Your decisions based on you. I wanted this, and I want you are moving towards that area saying, I need to do this so that I can prepare myself to do this. Long term. One young man. That's what took place. You need to talk to your counselors. Now, Dr. June is actually how do you go to school? You have these counselors. Everything we know with the senior year. High school, senior year, high school. And we found out last term, last quarter, trying to graduate. There were some classes he didn't have. They didn't need it. What are you thinking of? Think graduated? Because he didn't know what the need was. It was there sitting there. So I'm gonna let you look at it. But you told him. Before you got there. If he would have figured it out beforehand, and got there and said, you know what? I got some school I could take up extra classes in. You know, we went to three math, three physical education classes, we only need one. And you took that science class. Said, you okay, huh? You're not in trouble.
Oh, no.
But when you think about from that standpoint, your financial position has to be looked at as a big picture, not one item, right? Insurances, investments. Then you got to say, when do you want to retire? When you need to ask that question?
I should have been already asking.
Not already. Right, you should have been done that, right? Right, so when you say, I want to retire on this date, you have to ask yourself, okay, that's the date I want to retire on. How much money do I want to have per monthly basis coming into my household that I will live on? Have you asked that question?
I thought about it, but it's not something I have done in detail.
You have to ask that question. I said that on my class and I explained to them, let me show you something. Husband and wife sitting there, right? First thing I do is give them 2 blank pieces of paper. 2. I want you to write down how much you want to have coming in on a monthly basis when you finally hit no longer working. I want you to do the same thing, and I don't want you to show her yours, and I don't want you to show them yours. What do you think I get?
Yeah, you're gonna probably get two different numbers.
And sometimes they're so far off base, it's not possible for them to make their objective. But yet they're in the same household. And he's working real hard to try to get his income up to that level, and she's spending like this running water
I'm probably what I'm doing.
and didn't realize it. But yet that same, they're on the same boat, trying to make retirement that date, and that is not happening. Yeah. That's why it's coming and going. That's why. Yeah. See what I'm saying? You have to ask yourself when you look at your money in your wallet, that money in your wallet, you know what that's for? Well, that money in your wallet for parking, for McDonald's. Oh, I see something over that light. That's what that's for. Yeah, that's in your wallet. That's your spending money. But your operating money should not be in your wallet. Your retirement money should not be in your wallet. That's 3 different buckets, right? Oh, by the way, what about the emergency fund? And you know, one day that time will blow and you ain't gonna have nothing to do about it. What do you think they use as an emergency fund? A credit card. Yeah, that's what happens. A credit card. I have wealth. Or debt. Sometimes the debt passes the income coming in. Isn't that interesting? Right? So, if the person set up, typically, if I say, you know, 3 times your income for emergency fund, 3 times your monthly income for your emergency fund, 3 times your monthly. That should be a goal. That covers anything. That covers somebody out of town. You got to catch that flight to go out of town, take care of that family emergency. See what I'm talking about? That major car event, you gotta have a car right now, that takes, you know, flood that great car. Now, how do you get to an emergency from once you've established it? Because it's not in the wallet. How do you get to it? What I do is I show my clients, this is what. Good money. Operating money, spending money, retirement, emergency, right? 4 different pots. That emergency money, in order to get it, I give them 3 strings, or pencils or pens or whatever. So let's take this. Take this money, this string here represents your spending money. And I take one out of it and I says, take it out of my hand. And when they take it out of my hand, there's no tension. 0 tension. Right? And I said, okay, now I want you to take some emergency money. Emergency money, when they take that string, how do you think it feels? You think it feels the same way, no tension? Huh? What? Why no? Huh? It's what, it's not there? No, so you gotta have some tension on it. You gotta have some tension getting it out of my hand because there has to be some communication. There's gotta be some communication with the husband. There's gotta be some communication with the wife. And you say, honey, I got an emergency.
But we both need to agree on what the emergency is.
Bingo, that's the tension. Spending money, there's no conversation.
Yeah.
See what I'm saying? So when we have that conversation, when you have that conversation, and you look at him and say, there ain't no emergency because you want a boat. There ain't no emergency. No, I wanna go fishing with guys. No, that ain't no emergency.
Yeah.
So what happened? When it comes to your operating money, the operating money is preset dollars based on what it takes to operate your house. Food, housing, light bill, water. That's those bills are typically set in place. That's typically set in place. As it's set in place, you can set this in a budgetary area. You can operate without any conflict and it's put it on automatic dollar, automatic balance. And it has its own separate account. Because you know those things have to be paid. Yeah. Well, by the way, he got water, you got water. Your water is not his water. His water is not your water. Now, you say, so my friends, my job is not to
That's about right. Would they get it at 1 o'clock? That's about right. Well, a light, and so if it's not a verdict, I mean,
Oh,
I would
or
imagine
just
it's a
some
question.
Detention,
Yeah.
question or a verdict.
Yeah. Hey, can you guys head on back? The jurors, the light is on. I don't know if it's a question or a verdict, but the light is on. Okay. All right. Thank you.
So you say little one, how old was your little one?
He's 1.5 years
Oh, my
old.
goodness.
So, yeah. I have an older daughter who just graduated college. I moved to Atlanta because I was dating her mother. We never married, but I mean, I moved when my daughter was 4 here to Atlanta because I didn't want her growing up without her dad. And so tried to do the co-parenting thing as best we could. But, you know, relationships are tough and just took me a while to get to marrying. And when I finally did, at the age of 47, 3 years ago, I married a younger woman. And of course, she wants to have a tribe. So I said, I'm gonna be 72 years old when my kids are graduating high school. And my prayer is that I can get around without a cane or a walker, you know.
Just in the news. A day or two ago, Al Pacino at 80 something just had a baby.
Al Pacino, Robert De Niro, they're just, I mean, I don't know what's going on or what they're taking, but I need some of it because I don't know if I'm gonna survive. I mean, I told my wife, I said, well, she was like, because she's been hinting, she's very proper. And I mean, so like when she started talking about having a second child, she came to me and said, well, I would like to have a meeting about expanding our family. And I said, yeah, I mean, that just kind of, I mean, who says that?
I don't blame him. I want to be able to look at the video and mess with it.
So that was just kind of funny. I said, well, I think we can kind of naturally make this happen if you know. Well, I just wanted you to be prepared. So we don't know yet, but maybe so. Maybe they now. You might climb. Is it a question? Yeah. Oh, okay.
Questions?
Questions? Yeah.
Yeah, I told Miss Collier to come on back. What you got? I'm standing like this. No, right? Hey, man, you got another pair of glasses? I got your glasses. I know how many pair you got, because I think I left a pair in the box. Did you pick up two? Oh. Yeah, I did. Yeah. Hold on. I can. Yeah, those yours. Yeah, you got both of mine. Hold on. They both mine. Yeah, yeah. They both mine. Yeah, these yours. I know they are. Yeah. Yeah, I got your glass. Oh,
I think they're his now.
Let me see that pair right there.
huh?
There's one pair thicker than the other. Let me see that pair.
No, it's the same. They're both the same brand.
But I got two pairs that look like these.
Yeah. All right, what is? Question. That's a question. Yeah.
He's coming.
All right.
Okay.
All right.
Oh, he calling me right now. That's 2 minutes.
Did you end up getting a call?
No, she coming right.
Gotcha.
Everything's on top. Tuesday, you know, yesterday.
Yeah.
What time we left it on work? Right.
But I think he said.
Yeah, we'll have to come back for that. They asked him. You know what they asked. We don't know what it is. They asked him. So yeah, they asked him.
Of course, now order remains seated.
All right, back on the record with State versus Justin Collier. We have a question from the jury that's got several subparts and issues to talk through. So provided a copy to counsel. I will also mark the original as Court's Exhibit 4. Then we can start working through this. All right, so the first question from the jury is one I'm a bit befuddled by, but it says, need further clarification on charges. What must accompany each other? It's unclear what other is referring to, but I think maybe the question is getting at if certain charges have to go together. And I think we might be able to find something in the pattern charges that you're to decide each charge individually, something to that effect. But any initial reactions from the state or defense?
If that's the fact of that question, I think the court's response is appropriate.
Yeah, without knowing what truly their question is, I'm not sure how to appropriately respond.
Need further, what must accompany each other?
Well, Judge, I've had that question before, so I can interpret it. I can go back there and straighten it out.
Yeah, I imagine so. My only thought on that is I could re-instruct them on the sentence, which is no person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. Or is there any other suggestion of how to respond to that? Or we can just say we are unclear of what you mean and leave it at that.
Yeah, we could respond that way. Can you be more specific?
All right.
Just to invite them to further. I would imagine that they may be thinking about murder and felony murder and how, the verdict form reflects malice murder and then or voluntary, felony murder or voluntary. But either way, yeah.
All right. The other thing I think I would tell them at the outset, because I think it comes up later in this note, is that the Georgia Supreme Court requires all communications to be in writing. And so further on down here, they say, can we discuss? And so my thought was to explain to them that everything has to be in writing.
Fair. When you say that in writing, and instruct them of that, Judge, I don't know if the court ever instructed, and I know I didn't ask for the instruction, but oftentimes they will give a numerical division and sometimes will say which way they're leaning. I think there is a charge on that, just so that, we're not out here, trying to figure out who's what and what's, if they're communicating with the court, I would just, I think the court's instruction would be, hey, you have to ask the question. That's the way you communicate with the court. We can't just have an open dialogue. And then 2, make sure in communicating with the court that you never, ever
discuss numerical divisions.
Yeah.
I understand. And I think that's a fair point. More so in the context here, it was just saying, because I think essentially it seems to me these questions they're working through it and they're trying to figure out to go through the evidence. And so skipping ahead, it says, are we allowed to choose the points in the video? Can we discuss? And so to that end, that's where I was just going to say that, no, we can't discuss it in open court because everything has to be in writing. So as it relates to the video, which is also, let's just go ahead and, I think we rope in question 2, which is want to see in video position of parties between Wendy's and CVS. How many feet? Is there a gap in the video footage? So any suggestions on how to respond to question 2?
I don't know if we could tell them how many feet is between, the evidence is in, so we can't do that.
No, we could not.
I don't think they would answer either question about if there's a gap in the video or not.
Right. So I guess for part 2 of this, which is really 3 questions, or a request and 2 questions. So the 2 questions, I would say the evidence is closed and the jury must rely on the evidence as presented.
Yes.
All right. How about to the actual video position request about Wendy's and CVS? Do we know what they're referring to there and how much we would want to play for them?
I just think that they can identify any portion of any video that they want to see, and the court can accommodate that request.
Yes.
And so, but I'm trying to be clear, what exhibit and what time marker do we think they're referring to here, and what should we actually republish?
I'm not sure we know.
I'm
that
not-
question.
Video position of parties between Wendy's and CVS. I think that's the
It would be on states 2
When
and
they're
states
running.
4.
running and the shooting occurs, and then maybe the CBS video itself of the running there. That may be what they're talking about, but I think we'll just have to ask. Exactly what they're gonna say.
All right, so essentially in response to the second request, you're saying that it's unclear which exhibit they're referring to? Or which aspect of it?
Yeah, but I think it may be unclear what aspect they're referring to. I think, we've only published the compilation, so I'm pretty sure they're wanting to see states for the compilation, but as far as where they want us to pick up the recording, I'm unclear on that.
Position of parties between Wendy's and CVS. I mean, the compilation was every angle that existed in video, right?
Yes.
It's almost as if, I mean, I don't, we don't go too far down this. This is just a very difficult question to respond to. What about this last aspect? Are we allowed to choose the points in the video? Essentially, they want to be able to have control over the laptop and the video itself.
I think they can direct me, I guess, to, stop it here, start it here.
But they would have to do that through written correspondence.
I mean, the court can provide them with the computer and the thumb drive and or disk to play back there and just instruct them, you're only to, play the video footage that you want, and just, you can't access the internet and all that kind of jazz, but
Okay.
there've been times where courts have provided equipment so that they can view it on their own and see it as long as they want, or if the court wants more control over the process, the court can just inquire what specific portion are you requesting, and we can play it out here in open court for their viewing.
Well, in my mind, this is a case that comes down to split seconds, and there's been slow motion and things like that. It seems to me that I would be perfectly fine with them having the ability to look at it on their own. And so if there's no objection to that, obviously we can try to control the manner and means, then that might answer all of their concerns here. So
I just know that States 2 contains all of the videos.
that's right.
And they're like 12 different channels. States 4 is the compilation. And so, States 2 has both, States 2 has the footage of the parties between the Wendy's and the CVS, but as does States 4, because it's a compilation and a segment of the Wendy's and CVS is contained in States 4. So I'm not sure which one they want. Do they just want to see it on stage 2 or stage 4? Just don't know.
Are those separate discs?
They are.
Stage 2 and 4 are separate.
And what about 3, the CBS video?
Also separate CD.
So, I mean, one thought is, first of all, the court doesn't have a laptop that, I don't know, is stripped down to only have basic media players on it. I don't even know what kind of media players would be needed to play this video. So is that something the state has and could provide them?
A laptop? I don't think so. I mean, I don't want to give them my laptop. But
We don't have like a juror or jury laptop.
I'm not aware of one. I just have to go and check if I see or somebody, but I've never, this is a new one for me. Never.
Yeah.
I mean, I will say that I do think that in most instances, while I have seen it done that way where a laptop is provided, more times than not, the court just invites the jurors out in the courtroom so that they can.
And I agree with you there. And I always thought the distinction was that's how we do it in state court.
Yeah.
And in federal, we just say have at it.
Yeah.
And it's so much more efficient to just let them actually be the finders of fact.
That's why I'm not opposed to it. But
And why I appreciate that, but apparently we're breaking the machine here to not to not even know how to get this to them. I guess I can guarantee you we're going to come out, we're going to show it to them once, and they're just going to end up more frustrated than ever because they want to be able to have control over the process.
Rewind, slow it down, speed it up.
they can have my laptop. Ain't nothing on it.
Okay, well, they can take.
I mean, I can shut down the Wi-Fi so that they can't turn it and you can direct them to not, I mean, so.
What kind of media player is it required to play these videos?
The cone
Media player. Well, mine plays on media player. I think he was playing on phone.
I got the cone, I got media player, I got GOB or GOM.
Mine plays on media player, so I guess he can cue it up to make sure to play and then.
All right, well, let's think through this. So is there anything on the desktop or, anything else? Is this a pretty clean laptop? I mean, I don't, in terms of like extra programs.
Let me see here.
Yeah.
We can just get in there and start looking at everything that he has on his work product.
I mean, we could give them specific instructions that the only thing you can do is to look at this media program.
Yeah.
Yeah, I think it's just easy to have them watch it out there. You could have been halfway through it by now.
Well, I don't know. I mean, look, I was in a vehicular homicide trial for 8 days, 2.5 days of deliberations. And we constantly had to pull the jury out like 5-6 times because of all the dash cam, body cam footage. And while that's how we did it in that way, I mean, I appreciate the fact that the autonomy that they have in the federal system to just kind of deliberate. Because they just want to look at it.
They probably want to play it a couple times in a row.
And then they go back, oh, I want to see it again. I want to see,
I mean, that's what I'm seeing here, but I'm recognizing the complications this introduces. I know they came with their own laptops that we currently have in a bin that they don't have as they're deliberating. That's an option. One of them using their own laptop, but I don't know what kind of media player, if it needs to be something extra or something new installed. All right, let's run through this from the top again. From the question 1, need further clarification on charges. What must accompany each other? The answer would be, we are unclear of what you mean. Can you be more specific? Is that an adequate response?
Yes, you know.
Position 2, want to see in the video position of parties between Wendy's and CVS. I guess let's try this. Let's just try it one time, then we can republish State's Exhibit 4. And as to the follow-up questions after that, I would say the evidence is closed and the jury must rely on the evidence that has been presented. All right.
Good.
And then for the third question, are we allowed to choose the points in the video? Can we discuss? As to choosing the points in the video, I think this might be the thing where, again, if we could just get more clarification. So I think in response to this third question is where I would say that it's required that all of our communications be in writing and just leave it at that and let them follow up by writing if they want to get more specific.
No objection from.
All right. All right. Can we tee up State's Exhibit 4 then? All right, let's bring in the jury. Yeah, I need to read from it though, and then I'll give it to you.
All rise for the jury.
All right, thank you, everybody. All right, members of the jury, we received a written note from you all, and we will respond as best we can. The first section said as follows: need further clarification on charges. What must accompany each other? And to that, we would respond, we are unclear what you mean. Can you be more specific? As to the next point, want to see in video position of parties between Wendy's and CVS. How many feet? Is there a gap in the video footage? In a moment, the state will be republishing Exhibit 4, which is the compilation video. And to the remainder of the questions in this section, we would respond, the evidence is closed and the jury must rely on the evidence that has been presented. And then finally, you asked, are we allowed to choose the points in the video? Can we discuss? And to that, we would respond that the Georgia Supreme Court requires that all communications between the jury and the court must be in writing. So with that, we're going to republish State's Exhibit 4, and then we'll allow you to retire again to the jury room. Let me ask, are there any concerns or issues with seeing the screen right now? All right. All communications have to be in writing. All right. Court's Exhibit 5 for the parties. All right, so to conclude, we will now be republishing State's Exhibit 4 at 1/4 of the speed. Yes, please.
Hold on,
And Mr. Lee, I think we said we're republishing State's Exhibit 4, so I think we would need to do it in its entirety. I believe it's 10 minutes in length. I'm sorry?
republish the entire.
It's 10 minutes in length?
It is.
Well, at a quarter speed.
Can we inquire of the jurors if they want to see it? Or do they just want to see the CBS portion or the behind the Wendy's of CBS portion?
No, I know this is just, it's a awkward situation here with the constraints of communication.
Can we stop? All right, Court's Exhibit 6 for counsel. Yeah, the last part of that is dealing with the Zoom video. I'm going to see if I can handle that on my side.
But every time you play it, I think the only way to remedy that is to add a little bit ahead so that the box can go by the time they start up.
Well, yeah. Should need to just let me see. Very well made.
I thought you were talking about that gray box that displays at the top of blocking the view. So the only way I know to remedy that is that by the time they get to the part, they want to see the box.
Okay, so we're gonna do that. Wait, while you're up here. Look at this about surveillance. There's no audio and the surveillance video goes back.
Yeah, there's no audio.
That's right. See the Matthew case? It's right here, this last sentence. If we can get them a laptop, we don't have to go through all this. Just something to think about. All right. All right, Mr. Lee, if you could put on the record here, we've consulted about with defense counsel in the state about Court's Exhibit. Was that 6 was the most recent one? And can you indicate for the record what you're about to publish and the time markers?
Publishing 10/15/43, and I hope that the gray box that we put on the top, that's gone by the time it gets to the part that the judge requested to be. And I will do that.
All right, Mr. Lee, do you believe we've reached the marker indicated in the note?
I believe so.
All right, let's indicate for the record where you're stopping it then.
From the timestamp of the media player, 10 minutes, 49 seconds. There's 45 minutes, or 45 seconds of the video remaining.
All right, let me get council to approach one more time. All right, members of the jury, final point here in response to your question about whether you control the video yourselves, we will take that under advisement. And so we would ask that you now retire to the the jury room to renew your deliberations. Thank you.
All right, the jurors.
All right, so just one, we'll see if that satisfies them in terms of Exhibit 4. Looking at some of the case law, though, that I shared with counsel, it does appear that silent surveillance videos could be back with them the entire time for them to review over and over again at whatever pleasure they wanted. And so it would seem to me that it might behoove the Fulton County District Attorney's Office to have kind of a naked laptop with nothing on it but media players for these kind of situations. Hopefully that'll satisfy them, but in the meantime, if you can put something like that together, great. But if not, we'll just keep them coming out. Anything else we should take up? Mr. Banks?
No, Judge.
And I just want to make sure there were a lot of bench conferences, and I think our court reporter was able to get all of them. But did you have any concerns about the procedure that just played out now? All right, any on behalf of the state?
No, Your Honor. Is that like new or old?
I think that's the old one. Deputy will take care of that. Okay, we'll be in recess again. Did you see anything like that? Get like a USB plug in. Yeah, I have a mine, right? But I guess like that. This attorney's office, we have like a dummy laptop.
Yeah.
Hey, what's up, brother?
Happy early Father's Day. Day. Happy early Father's Day.
How you doing, man?
It's got to do a single opening or close.
He's that good.
We did like 2 weeks.
Oh, are you okay if I go get my laptop?
Okay, go ahead and do that.
What do you have?
I have my personal one they can use.
That strategy, so when you prepare your fight with me, then you fight somebody else.
You don't know what you got in your back pocket. Full gate banks right out.
That's right. You know. But believe me, he called me for a case and I thought I was gonna sit there, right? He said, I need you to do this. And I said, how you see? I just read it this morning.
You're telling me it's reciprocal.
Yeah.
So
Yeah. Because when Gabe called you, he wants you to perform on the spot.
That's right.
He said, you may know if that's to you, how hard it would be.
I thought you brought him on this. Isn't that right?
Yeah, I did. Yeah.
All right.
Okay, see you in a bit. You guys get some lunch? How you feeling, man? I know your stomach was messed up.
Oh, yeah.
Was it something you had ate?
Yeah, I think so.
Okay. That nervous tummy.
Have a DVD player.
See, you have a DVD.
These don't have DVD players, these laptops.
Well, his personal one, might.
And I have one
Yeah, I have a.
Extended one.
with a USB.
I just.
Just need to probably use.
Yeah.
and just let them, with the evidence, and just let them have at it with the instruction that you can't use it for anything else. Beyond that, Judge, I mean, they haven't asked to see it again, but to preempt all that, let them have it so that they can go through it on their own.
I'm of the mind that carefully weighing the evidence, and I think whatever we can do to facilitate that. So, any other thoughts from the state?
No.
Okay, and we'll have Mr. Banks, did you get a chance to take a look at the laptop, is there anything that you wanted to see with it?
I mean, if they're just representing that it's a clean laptop with nothing. Okay. Okay. Have we deactivated the Wi-Fi capability?
I think the only thing that was on there was Word.
Other than that, Judge, I'm good.
All right, so that's what we'll do, we'll send it back.
All right, thank you.
Thank you.
Okay.
So deputy, whenever they're ready. Okay.
Oh. Okay, so right now they owe me 35.5, right?
They would have to actually.
35,500, right? Well, yeah, 35, yeah, 35.
But I'll never forget that.
You still there? Hello?
You need to mute yourself.
Well, Mr. Lee is not here, but I don't have any objection to that, Judge. I mean, I guess they could say to us, we're still working, or we need a break. And so I don't have any objection to the court's proposal.
All right. Well, yeah, we can wait a moment just to see if Mr. Lee has some input and may figure out phrasing and get someone who's got a bit better handwriting than me. All right, Mr. Lee, we were just talking logistics here. The plan is the proposal on the floor is to inquire whether they would like additional time or to return on Tuesday.
That's fine.
All right. I would imagine at some point we do have to have a hard stop today, though. And to that end, I guess I would ask the sheriffs what time they kick us out of here.
Last shuttle runs at 7:15.
I don't know if we want to stay that late, but we'll see what the jury says. All right, so I've just written down, would the jury like to continue deliberating? ? Otherwise, we'll adjourn and resume Tuesday morning. Any objections? All right. Since it's something I just wrote and read into the record, I don't really see a need to make it an exhibit. If they write on it in response, I'll of course bring it to everyone's attention. All right. I think we're on court 7. And so the signed response from the foreperson is, we want to continue deliberating until 6 p.m. for another check-in. So at this point, there's been no indication whatsoever of a deadlock. The only indication we've had is that they're going through the evidence. They've now got the laptop and the video. If there aren't any scheduling or logistical concerns from counsel or the parties, I'd say we see where we are at 6.
No objection.
All right, court 7 for the record, if anyone wants to inspect it. We'll be in recess. Yes, ma'am.
Yes, and go.
I know it.
They almost done.
Say need about 10 weeks.
Walk, you hear that?
This ain't even my leg. Oh, that's right. This is all the deputies there. Where everybody is. I always love it. No.
Hey, it's Monday, a holiday?
Yeah, Monday holiday.
In state? fair?
I know it's a federal holiday, but
Yes.
Are y'all open? Y'all not open?
You open, Gabe? You open your business? Come on now.
On Juneteenth?
Yeah. Yeah, sure.
Look, if I can work on the Sabbath, I can work on Juneteenth, you know what I mean? Yeah. I'm just gonna let you know, not that I don't respect the holiday, but at the end of the day, I've been up on some Sundays and Saturdays. You understand? And don't be confused, Sunday is the Lord's day, Sabbath is on. So all I can say is, if I can work on the Sabbath, doggone it, I better get to working on Juneteenth. Well, it's a wrap. Let him out for the weekend. Big Deputy King, tell them to come on inside. Tell them to come on inside. Big deputies. $1306, $1300. $1300 should be 26.
Can you come back and say? We have a verdict.
Remain seated. Court come to order.
Let's bring in the jury.
Ladies and gentlemen, before the verdict is read, if you guys feel like you're gonna have an outburst, please step out. Do not feel like you can't govern yourself, please step out in the hallway. Thank you.
All rise for the jurors. The president come forward.
All right, thank you, Deputy. Members of the jury, I've been informed that you've been able to reach a verdict. And so I would first ask of your foreperson Have you reached a verdict?
Yes.
And was it unanimous?
Yes.
Has the verdict form been filled in, signed, and dated by you? All right, if you could hand that to the deputy, I need to take a look. All right, sir, I would ask if you could publish the jury, or excuse me, publish the verdict by reading it aloud. Whatever makes you feel comfortable.
As to count 1, murder, we the jury find the defendant not guilty of murder. As to count 2, felony murder, we the jury find the defendant guilty of felony murder. As to count 3, aggravated assault, we the jury find the defendant guilty. As to count 4, possession of a firearm during commission of a felony, we the jury find the defendant guilty. This is 16th day of June.
All right, thank you.
Not a murderer. I'm not a murderer.
All right.
I'm not a murderer, y'all.
Members of the jury, I'll have to ask you to step out just for a moment. Step out. Yeah, let's have him step out.
Oh my God. I'm a good person.